Hello, everyone. And this week we are looking at the topic of false confessions. I gathered some information from some various sources, including from Dr. James Davidson, as well as the UC Irvine Undergraduate Research Symposium. Both of those had some really good information that was synthesized about false confessions, and I thought I would present that to you for this week. So when we're talking about false confessions, an interesting thing was said a long time ago. If a person is innocent of a crime, then he is not a suspect. And this is Attorney General Edwin Meese telling the American Bar Association that the Miranda decision advising those arrested of their rights was no longer necessary. That is from the 776 Stupidest Things Ever Said. Let's first talk about exonerations in the United States. Since 1989, there have been 1,740 exonerations. And you can see according to the map where those have been located and what they have been exonerated for. In Texas alone, there have been 241 exonerations. How do we look at exonerations? Like, what causes them, and what role do false confessions play in this? So this chart here shows that contributing causes of wrongful convictions are, if we look at the graph, 72% were due to eyewitness misidentification, 47% were related to unvalidated or improper forensics, and then 27% were related to false confessions or admissions. That's even more than coming from informants or snitches that gave possibly inaccurate information. So what's the big deal? What are the consequences of false confessions? If someone admits to committing a crime even though they didn't, well, that's on them, right? Well, no, there's a lot more to it than that. We can look at in terms of police, oftentimes they close the case once someone has confessed. They ignore some contradictory evidence. They refuse to admit that there was an error. Defense attorneys sometimes will presume the client is guilty since they confessed, and they'll pressure a client to plead guilty or plead to something. A 78 to 85% risk of being wrongfully convicted if the case is not dismissed prior to trial. So that means there's a high chance of being wrongfully convicted if your case goes to trial. And even judges, they can give a higher sentence because they feel like the person being accused hasn't shown any remorse. But the reason they're not showing remorse is because they didn't actually commit the crime. And then on the other side, prosecutors often will set higher bail, leading to more and higher charges. And since someone confessed, they can make it a centerpiece of the state's case. Juries are more likely to convict even if the confession was coerced. And we'll talk more a little bit about coercive techniques. And then post-conviction, the law almost never permits appeals based on innocence. So who would say I did it even when they didn't? So there are 4 I's of people that are at greatest risk. 1, they're immature, like juveniles. 2, they are impaired, such as developmentally delayed. 3, they're possibly imbalanced or mentally ill. 4, they're impressionable. And, people that perhaps don't have a lot of backbone and want to please. There are different kinds of false confessions. There's a voluntary false confession. Sometimes people do this for things like notoriety. There are coerced compliant false confessions. These are reasons such as they're solicited via interrogation tactics and desire to stop the questioning. The thought of going home or the perception of less punishment is a reason they might confess. Retracted confession, sometimes once out of the interrogation setting, the fact that the confession was false often emerges. Then there are coerced, internalized false confessions. The reasons for this may be they're attained via an impressionable subject's internalization of a crime due to the Reid technique. We'll discuss that also in a few minutes. So someone, for example, was lying about evidence, and this is often accompanied by the subject's memory lapse due to maybe drug or alcohol use. So it's almost like creating a false memory and taking the place of what a subject might not remember, and then thinking, well, maybe that they did do it. Then there are coerced reactive false confessions. The reasons for this may be third-party pressure due to confess, so like a gang member or an abusive spouse. And yes, I do see there is a typo there. And then there are coerced substituted false confessions. So the reasons for this may be the subject has committed a number of similar crimes and can't remember all their crimes. So they agree to a similar crime which is added on by the police. So oftentimes there are various pathways to get false confessions. This can be a misclassification error, so the police erroneously conclude the subject's guilty, and the interview becomes an interrogation. There can be a coercion error where police interrogate with coercive tactics. There can be contamination error where police contaminate the subject's story or false confession, where they shape the narrative with leading questions. As I mentioned before, there's something called the Reid technique, and this is a pathway to often a pathway to false confessions, or can be a pathway to false confessions. So what is the Reid technique? It's a 9-step method for an interview and interrogation taught to thousands of police departments. The prevalence of the Reid technique and its variations are minimalization techniques, such as soft sell tactics that provide a sense of false security, like you're helping them to justify the crime, and maximalization techniques, where you use scare tactics that attempt to intimidate suspects, like making up evidence that isn't there. So the difference between interview and interrogation is really information versus accusation. So more about the Reid technique. Police can lie to a suspect. So they can say, we have your prints, your hair, a witness identified you. Police can accuse a suspect. They can say, we know you did it. Police can use tactics that promote confusion and that lead to false confessions, such as attacking the suspect's alibi or interrupting the suspect's denials. Police can manipulate by suggesting face-saving alternatives or justification while noting, you need to do what's right, or we all just want to go home tonight. So when do false confessions occur? I talked a little bit about the 4 I's of the people that are vulnerable to false confessions, but they can occur when someone doesn't have representation, the Miranda waiver and waiver failure, so it's not voluntary, knowing and intelligent. So after a lengthy questioning, someone is exhausted. After abusive questioning, so again, this can go back to coercion. After an interrogator prepares a false statement and says, hey, I've got your statement here. We know you did it. Go ahead and sign. After an interrogator becomes convinced that the subject did it, and that leads to confirmatory bias. So when to call an expert? If there's a major felony, a vulnerable defendant, evidence of flawed Miranda waiver or interrogation, sooner rather than later, adequate funding, adequate records, and due to a court order. So what is the expert's task? Well, they need to identify the referral question, review multiple sources of information, interview the defendant, convey a verbal report, prepare a written psychological evaluation, and then testify. So again, 3 main referral questions. The Miranda waiver. Did the state fail to prove by preponderance of evidence that the defendant knowingly, intelligently, and voluntarily waived their Miranda rights? And then for a voluntary confession, did the state fail to prove by preponderance of the evidence that the defendant's confession was freely and voluntarily made under the totality of the circumstances? And knowing and intelligent confessions. Should the court suppress the defendant's statements to the police because the statements are highly unreliable and virtually uncorroborated due to coercion or other factors? So one of the other things that can happen when asking the referral question is, was the subject a vulnerable person? Again, were they immature, impaired, imbalanced, or impressionable? Does the subject voluntarily show without prompting culpability? And were interrogation techniques likely to prompt a false confession, such as the things we listed before, such as deception, coercion, leading questions, suggesting withheld facts to shape the subject's statements, lengthy interrogations of more than 2 hours, not recorded or poorly recorded or documented, police preparing the post-interrogation admission confession statement for the subject, and things of that nature. And then the expert's task is to review multiple sources of information. So what was the setting? Where was the person interrogated? What was the room like? Who was present? What was the time and temperature? And what was the length of the interrogation? Was the person given food? What takes place on the record? Was there audio, video? Was it just written? Can everyone be clearly understood? How was the interrogation conducted? Were interrogation techniques used that could prompt a false confession? And was there evidence of the defendant's culpability? What is contained in the police report, the 911 calls, the person's health records, and then the background information of the defendant? The expert also needs to interview the defendant. Is the defendant a vulnerable person? Does the defendant voluntarily show without prompting culpability? What are the defendant's strengths and weaknesses? What was the defendant's mental and physical state at the time of the Miranda warning and waiver, during the interrogation, and upon confessing? What are the results of a psychological evaluation, clinical interviewing, and testing? What does the defendant say about their own confession? And then the expert's task is to convey a verbal report. The verbal report briefly summarizes the findings and provides enough information for the ADA to determine whether or not they should proceed with challenging the Miranda waiver and/or the confession. Then they can prepare a written psychological evaluation. The psychological report would present in defensible detail the following: the referral question, the notification, limitations, procedure, and data sources, the history, prior psychological evaluations, forensic interview, forensic assessment of understanding, forensic assessment of malingering, and discussion and conclusions. And then the expert can testify. Some psychologists, by virtue of their knowledge, training, and experience, are able to assist the court in each of the following areas. They can assess the physical and psychological environment in which the waiver was obtained. They can evaluate the defendant's mental status, including psychopathology, intelligence, memory, and comprehension. They can reconstruct the defendant's mental state at the time of the waiver or the confession, and they can assist the court in understanding the intersection of all of these factors. So these are some great resources that talk about the Innocence Project and false confessions, which I thought were very helpful in helping me put this together. And also something else that I want to talk about with regards to false confessions. So there sometimes is a myth of the psychological interrogation, meaning innocent people do not confess, or at least that's oftentimes what the general public think. And who are made up of our jury system? Who are our jurors? Well, there are people just like you and I who are public people who don't necessarily know some of the ins and outs about how people can be interrogated and or why they might give a false confession. So anecdotal evidence suggests that the general public believes that the use of psychology is not sufficiently coercive to elicit a false confession. They also believe that it is highly counterintuitive to think that someone would confess to a crime they did not commit outside the bounds of physical coercion, such as doing such obvious violation of self-interest. So people actually think that someone wouldn't necessarily commit to a crime unless they were physically coerced or possibly beaten or abused while they were being interrogated. So the mere presence of a confession drastically increases the likelihood of a conviction. So if someone confesses, there is a good chance that that person is going to be convicted. So this whole idea of making sure we understand what false confessions mean, how they occur, and that there are experts that can testify to how someone or why someone might have given a false confession are important. Confession evidence returns higher conviction rates than either eyewitness testimony or character testimony. And studies have estimated that a false confessor faces a 78 to 85% risk of being wrongfully convicted if the case is not dismissed prior to trial. Again, how do we protect the wrongfully accused from their false confessions? Well, I talked about how we can use an expert in the field to refute the false confession or talk about the circumstances that led to a false confession. We can also have improved police training and education on the phenomenon of false confessions. We can do mandatory electronic recording of interrogations and confessions to provide an objective record, meaning if someone does give a false confession, if everything is recorded, we can go back and look at how was that confession made, under what circumstances. And then changing the law to require confessions to meet a standard of reliability prior to admission. Expert witness testimony to educate judge and jury on the coerciveness of police interrogation and the possibility of the elicitation of false confessions is also something that we can do to help people understand how coercive techniques can really lead to false confessions. Again, does the general public acknowledge that coerciveness of psychological interrogations exist? And does the general public believe that psychological interrogation tactics can elicit false confessions? These are all things that we really don't necessarily know the answers to. Again, here's some more resources from where I found this information. Hope you found the video helpful. I look forward to your feedback if you'd like me to do more of these. And I hope that you found this information and topic as fascinating and important as I do.